Where's Mr. Carter? In custody? Okay, no, it's gonna be a no. Are you gonna go to speak to him so we don't have to bring him up?
Yeah, I'll let him know it's being dismissed.
Okay, sounds good. You know what the prosecutor is? Sounds good. Who's here on behalf of Darwin Collins?
Yes, I am.
So that's you're Mr. Collins? And Mr. Donnelly, you already explained to him
Without prejudice?
yes. Donna Moore. Mr. Coons, or someone from Mr.
He
Coons'
was,
office?
she said he was in down the hall. You want me to go get him or just?
He's in another courtroom?
Yeah.
Okay, I'll wait for him to come back. Stephen Robertson, who's representing him? Is that Ms. Donnelly as well? Mr. Lee?
I'm sorry.
Is Ms. Donnelly representing Stephen Robertson? Stephen Robertson here? Are you
Yes, she
represented,
is.
you're represented by Ms. Donnelly?
Yeah.
Price needs to be reset, and then Torres. Mr. Coons, did you explain to your client what without prejudice means?
Yes, Your Honor.
Chair Williams is represented by Mr. Woolley.
Yes, Your Honor.
Collins, could you explain to her what without prejudice means?
She will, Your Honor.
Okay. Oh, no, we're resetting prices out. On the record in the matter, for the people of the state of Michigan versus Hannah Price. File number 23-00945 FY, council appearance.
Jeff Redowitz on behalf of the people, Your Honor.
Morning, Your Honor. Melissa Patrick on behalf of Ms. Price, who is here to my right.
Good morning. Okay, so today was the date that was set for a jury trial. However, we are calling a jury on a matter with a lower case number. So this matter will have to be reset. Yeah, we had witnesses here.
Yes, Your Honor.
Want to do next today or if the defense is available. October 2nd at 8. It's October 2nd, what for you?
It does, Your Honor.
We'll be set this for October 2nd at 8 a.m.
Thank you, Your Honor.
No problem. Any additional matters for the record today?
Nothing from the people, Your Honor.
None for the defense. Thank you.
Thank you. Same to you. Okay. We're on the record in the matter of the people of the state of Michigan versus Matthew Torres, file number 23-00818. Council appearance.
Jeff Bradowitz on behalf of the people, Your Honor.
Assistant Public Defender Sarah Donnelly on behalf of the defendant Matthew Torres, who is present and appearing to my right.
Thank you. This is the date and the time that was set for a jury trial, Mr. Torres. However, we have a trial that needs to proceed. It has a lower case number, which means it's older than yours. So we have to proceed on that one. Did we have witnesses here?
Yes, we do, Your Honor.
Okay, so what we'll do is we'll reset your matter for another date. October 16th. October 16th at 8 a.m. Have any questions at this time? Any additional matters for the record, counsel?
I just wanted to mention briefly for the record, and I have informed defense counsel of this. When this incident took place, I was working as Judge McCormick's law clerk at the 30th Circuit Court. Judge McCormick, I believe, is the judge assigned to the family court matter involving Mr. Torres. However, I did not witness the incident and had no personal knowledge of it outside of what I heard around the office. So just so that's on the record for clarification.
Right. Okay. Counsel?
No, Your Honor, thank you.
Thank you. You're all set, sir, okay? What's your name, sir? What is your name?
David Carey Niles.
Okay, David Niles. Okay, you have to put your cigarette or whatever you're smoking out during your court proceeding, okay?
Yep.
Where's Mr. Staples here? We have a city manager today?
Your Honor, we do have Corey Goss's review. At 9. He is also a felony matter. I'd appreciate actually, having you.
We don't know who Juan is. I see Juan's iPhone. What's your name?
Antonio.
Did you say Antonio Pittman?
Yes.
Okay, very good. Is Mr. Dunwoody Moore here?
Your Honor, I have not been able to get a hold of Mr. Dinwiddie Moore in regards to sentencing. I tried this morning as well, which was
What's your page warrant?
Dinwiddie Moore. Yes, he actually has cases in front of Judge Buchanan as well, traffic matters. And then he
Oh, I
has.
thought he had something going on in the circuit.
Yeah,
Since
felony
he has a
insurrection.
retrial on the 16th. Okay. I'll cross the warrant if you can find it, but,
Okay.
okay. And then we're on the record in the matter of the people of this state of Michigan versus Wesley Frank. Number 23-01251. Council appearance.
Jeff Rodowitz on behalf of the people, Your Honor.
Your Honor, Attorney Burnett Levine on behalf of Wesley Frank.
Okay, Mr. Frank, how are you?
Good, how you doing?
I'm well, thank you. Today was the date set for sentencing. I do have a pre-sentence report. Did you go over that with your client?
I did, Your Honor. Thank you.
Do we need to make any corrections, updates, or deletions?
None at this time, Your Honor.
You can make allocution.
Thank you, Your Honor. Appreciate it. So I'm just going to point the court's attention. I'll keep this very brief to what's labeled on the PSI report as officer's concern. It's not actually labeled as that, but that's what it's called. It's within the frame of a recommendation. But I can completely understand, I guess, the conclusion that my client was deflecting blame instead of being accountable based on his own handwritten account and what he apparently told the interviewer. So what I'm not here to disturb or disrupt that, but I just want to add a little bit something to clarify the reason that happens, and that to the extent that we want to get him to a place of greater accountability, I think it's important to find out the reason that he's not accountable right now, or at least at the time of the interview. So it's not like he's reluctant to accept responsibility for what he did. He and I have gone over the events numerous times, and in the most tactful way that I can say it. I think this is a matter where there's a little bit of a cognitive issue. I think he can benefit from a program that's designed to stimulate a little bit of a cognitive maturity in him so he could account for things a little bit differently, a little more thoughtfully. In no way am I trying to insinuate that he's got a problem that's big enough to question whether he can contribute to his own defense. So I'm not exploiting that ambiguity. I'm just saying that he does have a little bit of an issue, and I infer that from talking to him. Sometimes it seems like he's a little bit complacent and takes him a while to get to a place of responsibility and a greater sense of awareness, sort of out of the assembly line, sort of, yeah, and he kind of lulls back into this thing. So I think that could help him, but it's not like he's incapable of being accountable, just he's not there yet. But I do think to help him avoid this specific type of circumstance or any other things where he lacks maybe the maturity to have a little bit of a wiser decision making. I think there's a program that used to be called Thinking Matters. If that's still available, I would ask the court to order that as one of the components of his probation. And really, it's more reason to have him go to probation, not suspend jail sentences, to kind of coerce him to do that so that it can benefit him and that he's not in this position. I think it'll help contribute to avoid him being in the same position here later on down the line. But beyond that, again, I've talked to my client. Initially, he does understand what's happening. I just think he's sort of cyclically, he starts lulling out of things to an extent if he's either giving too much information at one time or if too much time lapses since you have an exchange with him. Maybe it's some undiagnosed massive ADHD or something to that effect. But I just wanted to clarify, he's not harboring malice. He's not accusing the animal or anything like that. It's more of he's just he yields to the lowest hanging fruit, and it happens to be the wrong thing to say at the wrong time with the interviewer. But with that said, we're asking the court to order probation. He doesn't have prior conviction, so that bodes well for that request, and that's essentially it.
Thank you. And did your client wish to make a statement for himself?
He said he did, and I hope that he does, and hopefully he takes this opportunity. Mr. Frank, you heard the court. Would you like to say something?
In terms of my case,
I already take full responsibility for it. I'm not justifying my actions. I just got like some anger issues from time to time, but I keep it pretty mellow for the most part.
Yeah, but you recognize that you might have some issues with anger from time to time?
In terms of like, I get like road rage. I don't go crazy and like attack people up there. I just.
Well, that's not good. You're an Uber driver.
Yeah.
You gotta get that under control if you're gonna drive an Uber, right?
Yeah.
You can't get a road rage.
Not to the point like I'd be like, oh, that was dumb, or why would you do that? I don't like go crazy.
That's good. Just takes a little bit of patience, right?
Yeah.
Okay, I reviewed your precinct's report. You don't have any other convictions. I don't have any reservations based on our interaction about your ability to understand and appreciate the severity of your actions. You state you take accountability. And whereas the report did opine that, or state that there was a concern about you seeming to have deflect or put that, put the responsibility on the animal, that could just been a misunderstanding or interpretation of what she thought she heard. It could have been you just explaining what you believe happened that led to this action. And so the recommendation for probation would be appropriate, just because I think you could benefit from some programming, one being anger management. And then there's a suggestion for you to do MRT, which is a moral recognition therapy. Your attorney is requesting that the court order thinking matters, if that's a program that can be ordered. So I'm not sure that that's still an available option, but if it is, we'll make sure that you get involved in that. You have a large amount of restitution that would be owed to the Ingham County Animal Control, and so that will be ordered as well. So I am going to adopt and amend the recommendation of probation. So the recommendation was for 9 months probation. I'm gonna give you 6 months. Hopefully you can get everything done in that time frame. While on probation, you're not to engage in any assaultive or threatening behavior. Do you understand that?
Yes.
You're not to purchase or possess a firearm, ammunition, or dangerous weapon. Do you understand that?
Yeah.
You're not to use, purchase, or possess a marijuana, alcohol, or controlled substance unless you have a valid prescription. You understand that?
Yes.
You will be required to submit to random preliminary testing while on this term of probation. You're responsible for the cost of that. I'm going to order that you participate in the MRT, which is the moral recognition program, as well as anger management. And then I'm going to order that you participate in thinking matters or a similar program as ordered by probation, okay? And you're still employed as an Uber driver? You need to maintain employment while you're on probation, and you will be required to provide evidence of that employment, okay? Do you have any questions about your probation at this time? Okay, there is a $30 per month oversight fee that you're responsible for while you're on probation. There's a $75 crime victim rights fee that must be assessed, plus a $50 state minimum cost that also must be assessed. You owe restitution to the animal control. in the amount of $1,424, okay? $1,729 that you owe in fines and costs. I'm gonna waive discretionary fines and costs because your hearings will be full with just this amount. And you'll be making monthly payments on that, okay? Do you have any questions so far?
How much monthly am I gonna be paying?
So when you meet with probation, they'll go over this order, and then they'll advise you of what your requirements are. You're only on a term of 6 months probation. So right now, if you divide that total amount of $1,729, says you owe $288 per month. I'm not gonna require you to pay $288 per month, okay? It'll just make monthly payments, because even after you complete your probation requirements, I'm more concerned about you really focusing on that programming. I can refer the balance of your restitution to collections, and you can continue to make payments after probation, okay? Do you understand that? Okay, so don't get caught up on trying to figure out if you can make it almost $300 payment a month on probation. You're not gonna be required to do that, okay? Do you have any other questions? Is that a no?
No.
Okay. Okay, there's an advice of rights here. It's related to probation. It gives you the options and explains how you can request early discharge from probation. Your probation officer can make that request on your behalf, but they don't have to, or you can make your own request after being on probation for half of the time I ordered, which in this case would be 90 days, because I ordered you to do 6 months of probation. But during that 90 days, you would have had to complete all of the required programming, and you could not have had any violations. You understand that?
Yes.
Okay, then you can make your own request to be discharged early. You do not have the right to court-appointed counsel if I set that for a hearing to address your request. However, you can hire an attorney if you want to have an attorney represent you for any hearing for early discharge. You would be eligible to make a request for early discharge unless you were on probation for domestic violence, criminal sex crime, stalking offense, or an offense where guilty but mentally ill was asserted. That's not the case here. So you would be eligible to make that request within 90 days, okay? Do you have any questions?
No, ma'am.
Any additional matters for the record, counsel?
No, Your Honor, we
Nothing.
appreciate it. Thank you very much.
Thank you. You're all set. We'll get you down to probation, okay, sir?
Thank you.
Let's see. Who? Bauer. On the record in the matter of the people of the state of Michigan versus Rosanna Bauer, file number 23-01250. Counsel.
Jeff Reynolds on behalf of the people, Your Honor.
Assistant Public Defender Sarah Donnelly on behalf of the defendant, Rosanna Bauer, who is present standing to my right.
Okay, this is the date set for a final pretrial on a dog fight. We have a victim here,
Yes, we do, Your Honor.
and how are we proceeding?
Yes, Your Honor, at this time, I believe we have come to a resolution in this matter, and that would be for the defendant to plea or accept responsibility, for to a civil infraction, and that would be under MCL 324.504, which is a Department of Natural Resources rules for the protection of land and preservation of lands and property. And that there would be the penalty for that civil infraction is a fine no greater than $500. I believe we have agreed to a fine of $125 for that, as well as I believe $30 in restitution to the or to the victim.
So you had a
Sorry.
Killebrew?
Yes.
Of sentencing?
Yeah.
Your Honor, I was hoping that we could just do impeding traffic for 125. I didn't think there was any objection to that. There was
Yeah,
agreement.
because I'm trying to figure out what is the name of this civil infraction that you just, what is it?
It is the Department of Natural Resources Rules for Protection and Preservation of Lands and Properties. It's one I've used before, Your Honor.
And like I said, I was just using impeding traffic. 'cause
And
we've used that before.
what is the benefit of using that and how does that help you?
It doesn't, I have no objection to impeding traffic either. Your
Okay,
Honor.
because
That's
if
what I-
you're gonna make an agreement about the fine, and then why are we creating this?
That's fine.
And then
Use the
$30 in
special.
restitution. Yes,
Yeah.
we have
$30 in restitution to whom?
To the victim, Mr. Chase Scruggs.
Okay. So the people are offering for you to accept responsibility to impeding traffic. Do you want to accept responsibility?
I do, Your Honor.
Okay, fine, it's $125, plus there's a $30 restitution owed to the victim in this matter. You understand that, ma'am?
I do, Your Honor.
When can you make payment?
Today, Your Honor.
Okay, I'll just need a restitution form and then
Yep.
we'll be all set. Do you have any questions today?
No, I do not, Your Honor.
Any additional matters for the record?
Nothing from the people, Your Honor.
nothing for defense. Thank you.
You're all set.
If I can have just one moment, it's in the police report, there are 4 different addresses. Scruggs, just so I can go get his address. So I
No
can have it.
problem. Did you need to speak with anybody that was on Zoom? I have Pittman here and then, I don't know that you're representing him.
I don't believe that our office rep, I think they both declined public defenders, so.
Very good. Okay, so then we need Mr. Gladwin. Pittman and who was the other person? They might have left.
Niles also.
Oh, David Niles.
Mhm.
That's right.
Corey Goss.
Corey Goss is here and who's his attorney? Mr. Abbott. You just need a prosecutor. On the record in the matter of the people of the state of Michigan versus Corey Anthony Goss, file number 20-01488 and 20-03656. Council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Good morning, Your Honor. John Abbott representing Mr. Goss in 203656 FY.
And Assistant Public Defender Sarah Donnelly representing Mr. Goss in file 20-01488 OM.
Matt Staples on behalf of the city of Lansing.
Okay, today was the date and the time that was set for review. Looks like back on May 22nd. I entered an order adopting the report from the Center for Forensic Psychiatry deeming the defendant incompetent. He was awaiting a bed. How are we proceeding?
At this time, Your Honor, it's my understanding that we are still awaiting a bed for Mr. Goss, so I would leave it to the defense to elaborate further on any progress that's been made.
Your Honor, first, the order that I have regarding competency, I believe was May 2nd, not May 22nd.
May 22nd was the date that I had a hearing.
Anyway,
Date stamped it.
there's no.
And this report I have, I think, is actually from May 9th. I could be wrong. Yeah.
Okay. Anyway, he continues to treat with CMH on a regular basis. It's my understanding, based on my most recent communication from the state, which was in May 16th, they're still waiting for a bed. There's a 15-month time period, which I expect will run out in August of 2024. We're not there yet. So I guess we'll just The request is that we continue as we are right now. Things seem to be going well. He has no new charges. His treatment at CMH seems to be successful.
Did you want to add anything, Ms. Donnelly?
Yes, Your Honor. On the city matter, he would only have 30, the state would only have 30 days to restore him. So I believe that Mr. Staples was going to make a motion on the record.
Mr. Staples?
That's correct, Your Honor. This was issued on a ticket, given what Ms. Donnelly stated and what appears to be the unlikelihood of that occurring. The city would move to dismiss the charge of, I believe it's open alcohol in public.
That case will be dismissed. The other one we will set for a review. Mr. Abbott,
Please, Your Honor.
how much more time do we need to go out?
Many days.
Okay, sounds good. Can we get a date? I just gave you. No, November 13th, at what time? 9:30. At 9:30.
November 13th.
That's correct.
Thank you, Your Honor.
No problem. Any additional matters for the record today?
Nothing from the people, Your Honor.
Not from the defense. Thank you.
Thank you. We see Jacob Mann today. He was in custody. He's not in custody now. Then Mr. Brodowitz, you need to meet with Mr. Niles and then Mr. Pittman. They don't have attorneys.
Mr. Navarre, can you hear me? Mr. Navarre?
What's going on, buddy?
On the record, in the matter of the people of the state of Michigan versus David Niles, file numbers 23-01850 and 851, council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Okay, Mr. Niles is present today without counsel. And you met with him. How are you proceeding, Mr. Brodowitz?
Yes, Your Honor. At this time, Mr. Niles provided me a copy of the license for the dog in question, Buddy, and has shown me that he has taken steps to secure the dog and correct the dog at large issue. So at this point, people would be moving to dismiss this ticket for compliance.
Okay, both tickets will be dismissed. You're all set, sir.
Thank you.
You're welcome. Okay, we're on the record in the matter of the people of the state of Michigan versus Antonio Pittman. I file numbers 23-018939495. Council appearances.
Jeff Brodowitz on behalf of the people, Your Honor.
Okay, and then Mr. Pittman as well did not have counsel, correct? Mr. Pittman, are you there?
Yes.
Okay, I need to see your face, please.
Oh, sorry.
Okay, thank you. Counsel, how are we proceeding?
Yes, Your Honor. At this time, Mr. Pittman has provided me with a copy of the license for both dogs in question and shown me that he has had a fence installed in order to correct the dog at large issue. So with that, the people would be moving to dismiss the ticket.
Okay, these matters will be dismissed. You're all set, Mr. Pittman.
Thank you.
You're welcome. Who's on the iPhone? What's your name, sir? Sir, can you hear me?
Yes, I can.
I guess only one person can hear me.
I can hear you, Your Honor.
Okay, very good. And then who's on the iPhone with the champion shirt on?
Javon Haynes.
Javon, do you have? Thank you. Javon Haynes. And who's on the iPhone with the other shirt on? Okay, well, if you can't respond, then you get removed. Okay. Let's see. We have Eric Leland present.
Your Honor, yes, he's sitting there.
Okay, on the record in the matters of the people of the state of Michigan versus Eric Michael Leland, file numbers 22-02373747577677. Council appearances.
Jeff Reynolds on behalf of the people, Your Honor.
Assistant Public Defender Sarah Donnelly on behalf of defendant Eric Leland, who is present and standing to my right.
Today was the date we set these matters for pre-trial. How are we proceeding?
Yes, Your Honor, after conversations with the defense, I believe Mr. Leland has one of the dog licenses here with him. However, he was unable to find the other one. And in order to give him time to address the dog at large issues, I believe a defense would be asking for a 30-day a reset of 30 days on this matter to come into compliance and for further negotiations on the dog bite.
So it doesn't take a year to get this resolved.
Yes, Your Honor. It's my understanding that Mr. Leland has got the dog's license back in April. The at-large issue has been a little bit more of an issue or a bit more of a problem. He has gotten an electric fence installed underground, but now he's just needing the collars. He apologizes to the court for his absence, and obviously, he wished he could have corrected this sooner. He doesn't want to get any more tickets. That's why he's trying to fix it. It's my understanding we still don't have an idea on any restitution or need from the victim in regards to the dog bite, because otherwise they'd be setting it for final pretrial. But
where is the victim? You have contact with the victim?
I have not had contact with the victim yet, Your Honor. So let me check and see if our office.
There's one, two unlicensed dogs. You've seen proof of one being licensed?
yes, Your Honor, like I said, I have the proof that one of the dogs was licensed in April.
Yeah, I do have both of them.
Did you license at the same time?
Yes.
All right, you just couldn't find the other one?
No.
Yeah, so we
They
should
should have
have,
all been together, but
you're sure that you're gonna be able to locate that?
100%, 100%.
Licenses should be at good.
And then the dog at large issue has not been addressed yet?
It's getting a lot better. I mean, the major problem was they were jumping the fence. I corrected that problem, but sometimes my door gets left open or open a little bit, and my dog likes to kind of just rush out the door wherever comes out. You know what I mean? So that is getting fixed by the electric fence. The underground fence. I don't have enough money to get the collar for it yet. It's kind of a pricey thing. So I got it buried, but I got it buried. I'm halfway there. I have to purchase the collar.
That's going to be taken care of in 30 days?
Oh, of course.
Counsel, are you dismissing one of these unlicensed dogs at this time?
With that, yes, in order to move this forward, Your Honor, I guess people would dismiss one of the unlicensed dogs at this time due to the one license that is present. And to answer Your Honor's question, our office has had prior contact with the victim. I personally have not had any contact with the victim in this matter.
Talking in my courtroom. Continue.
Sorry, Your Honor. As for that, the prosecutor's office has had prior contact with the victim in this matter. However, I personally have not had contact with the victim yet.
Okay, we'll go ahead and set this for final feature. Victim needs to appear in person. All of them. Set for final feature.
Do final pretrial October 2nd at 8 a.m.
October 2nd at 8 a.m. in person at the court. Okay, any questions today, sir? Any additional matters for the record?
Nothing from the people, Your Honor.
None for defense, thank you.
You're all set for today. We'll get you notice to appear.
Thank you. Thank you,
Is
Your
this
Honor.
for today's docket of some sort? Well, then it's not a priority right now. I got. Yeah, it's a need to do it for this, and I don't even know how to find them. System. Okay, who's representing? We not change this person's name. I'm sure it's not Becky, Mom. Who's the person identified as Becky Inman? Name?
My name's Bradley Merchant Savage.
Okay, Bradley Merchant Savage. Who's representing him?
I am representing Mr. Savage, Your Honor. And I would like a moment to speak to you.
Okay, sounds good. And who's representing Javon Haynes?
I am, Your Honor. I'm ready to go with Mr. Haynes.
On the record in the matter, the people of the state of Michigan versus Javon Marquise Haynes, file number 23-01551, council appearance.
Jeff Reynolds on behalf of the people, Your Honor.
Assistant Public Defender Sarah Donnelly on behalf of defendant Javon Haynes, who is appearing separately by video.
Okay, Mr. Haynes, today was the day set for pre-trial. I have domestic violence and 2 counts of malicious destruction of personal property. Council, how are we proceeding?
Yes, Your Honor, at this time, the people, I believe, have extended an offer for Mr. Haynes to plead to count 1 with 76948 eligible and a restitution on counts 2 and 3, and the people would then dismiss counts 2 and 3. However, with that, I would leave it for the defense.
Okay, I have a note here. There was an offer extended back on July 10th. And to plead guilty to the added count of disturbing the peace and pay restitution. Instead allow a reset pretrial to allow the defendant to consider.
If that was not in my system, Your Honor, but if that is the note you have, then I would stick by that offer, Your Honor.
Your Honor, yes, that's my understanding of what the offer is. At this time, I've discussed the offer with Mr. Haynes. He would like this matter set for final pre-trial and jury trial tonight.
Mr. Haynes, you are declining to accept the offer to plead guilty to an added count of disturbing the peace, and you want this matter set for final pre-trial, sir?
Mr. Haynes, you're muted, but in my understanding, he's not outright rejecting it today, Your Honor.
The offer stays open until the
Yes.
pre-trial. Mr. Haynes, you have to unmute.
There we go. Yep,
Okay. Okay, so you want this matter set for final pre-trial at this time?
yep. I'm not rejecting the plea offer as well.
You're declining at this time though, but you do, the offer will remain open until the time of your final pre-trial, okay?
Yep.
Is it yes?
Yes, ma'am.
Thank you.
Final pre-trial October 2nd. Trial October 16th.
Final pre-trial, October 2nd at 8 o'clock in the morning in person at the court. Your jury trial will be October 16th at 8 o'clock in the morning in person at the court. And again, your offer will remain open until your final pre-trial. Okay, sir?
Thank you.
You're welcome. Do you have any questions today?
No, ma'am.
Any additional matters for the record, counsel?
Nothing from the people, Your Honor.
And nothing for defense, thank you.
Okay, you're all set, Mr. Haynes.
Thank you.
Mr. Lee needs to go in the room with Mr. Savage, Mr. Savage. Representing Andrew Navarre. On my docket.
14.
Sorry? August 14th, I believe.
No.
Andrew Navari,
Yes, ma'am.
think you're a little early. Think you're scheduled for August 14th at 10 a.m.
Okay, thank you.
You're welcome. Who's representing Delvon Golden?
I am, Your Honor.
Mr. Golden, can you unmute?
I would need a breakout room with him briefly, Your Honor.
Can you hear me, Mr. Golden? Okay, your device is muted, but I'm gonna put you in a meeting room with your attorney.
Okay, is there any restitution? Or surrendering the dog?
It will surrender.
Hooper?
Oh, no.
Which one? Tyrone Hooper?
As for restitution,
Yeah,
Rye Blamo is present.
Tyrone Hooper, that's Mr. I don't know where, Mr. Blamo is. I
Mr.
did have
Blamo's
my-
on Zoom.
Oh, great. Okay, yes, I do. I'm ready to go with him. And then. Yeah. I'm just gonna talk to-
Mr. Blamo?
Yes.
Okay, hey, I need you to have on a light so I can see you. And you can't be laying down in court.
Yeah, I'm gonna go speak to Mr. Gold.
Can you see me? Hello? You heard?
Who's on the Galaxy A20 in the hat? Hello,
Hello?
Mr. Golden, I have you checked it. I'm trying to get the person's attention who's wearing a hat.
Oh, Anthony Burris?
What's your name, sir?
Anthony
Jackson or what?
Not you.
Noel Jackson.
You say Anthony Price?
Yes, sir.
Okay, thank you.
Ms. Donnelly?
She was just coming out of breakout with no objection.
On the record in the matter of the people of the state of Michigan versus Delvon Golden, file number 22-03537. Council appearance,
Jeff Brodowitz on behalf of the people, Your Honor.
Ms. Donnelly?
Hello?
Hello.
Yes.
Council appearance.
Thank you, Your Honor. Assistant Public Defender Sarah Donnelly. Assistant Public Defender Sarah Donnelly on behalf of the defendant who is appearing separately by video.
Today was the date that was set for a pretrial on animal abandonment. How are we proceeding?
Yes, Your Honor, at this time, the people have made an offer for the defendant to plead to an added count 2 of attempted abandoning cruelty to one animal and in a Kilber agreement that the defendant must surrender the dog, an agreement to pay restitution. However, I do not have a restitution amount at this time. As I looked in our file and I've checked with someone else at our office, and I do not believe we have received that from animal control as of yet.
Adjourn this back on July 17th so that could be received. And animal control is not provided it.
Not to my knowledge, Your Honor. I have not received an email back yet from Assistant Prosecutor Maycomer, who is usually our contact with animal control. So I'm not sure if she has it or not, but I do not see it in our file.
What are you asking for?
At this time, Your Honor, I guess I would add, if unless the court has other ideas, I would ask that it be set, I guess, for a final pretrial. I believe after conversations with the defense, it is the intent of Mr. Golden to accept that offer. Just he would like to know the restitution amount before he accepts it.
What's that for final pretrial?
For the second.
October 2nd at 8 a.m. in person at the court. Do you have any questions, Mr. Golden?
No, Your Honor.
Okay, any additional matters for the record, counsel?
Nothing from the people, Your Honor.
And nothing for defense. Thank you.
Thank you. You're all set, Mr. Golden.
And wouldn't it, October 2nd, when, what time?
8 o'clock in the morning in person at court.
All right, thank you.
You're welcome.
Yep.
On the record in the matter of the people of the state of Michigan versus Tri Blamo. File number 23-02118, council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant and Tri Blamo, who is appearing separately by video.
And today was the date that was set for a pretrial on a domestic violence and breaking and entering without owner. How are we proceeding?
Yes, Your Honor, at this time, the people have extended, I'll just say 2 separate offers, however, to the defense to see how they wish to proceed.
What was the offers?
The offers were either to, and depending, I did not have any contact with the victim, but the offers were either to plead to count 1 domestic violence with 7694A if eligible and dismiss count 2, or to plead to the count 2 misdemeanor breaking and entering illegal entry and dismiss count 1.
Thank you, Your Honor. Yes, at this time, we'd like it set for a final pretrial and jury trial.
October 2nd at 8 a.m. for the final trial. And October 16th for the jury trial.
Pretrial October 2nd. It's going to be at 8 o'clock in the morning in person at the court. Jury trial October 16th at 8 o'clock in the morning in person at the court. Do you have any questions today, Mr. Blamo?
No, ma'am.
Your offer will remain open until the time of your final pretrial. Any additional matters for the record, counsel?
Nothing from the people, Your Honor.
And nothing for defense. Thank you.
You're all set.
Thank you.
You're welcome. Is Mr. Hooper here?
Yes.
On the record in the matter of the people of the state of Michigan versus Tyrone Hooper, file number 23-02102, counsel appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Assistant Public Defender John Lee on behalf of Bradley Merchants. I'm sorry, Tyrone Hooper.
Today's the date and the time set for a Pre-trial and a fleeing in a fleet vehicle and driving while license suspended, open end talk to driver. How are we proceeding?
Yes, Your Honor, at this time, people have made an offer for the defendant to count 2, operating while license suspended, revoked, denied. And with that, people would dismiss counts 1 and 3. That I would leave it to the defense, Your Honor.
Okay.
Your Honor, Mr. Hooper has been in contact with the Secretary of State and is actually in the process of getting his license restored. It is his understanding that if he pays $125 reinstatement fee and clears up some issues from the old ticket, that will be possible. So we're looking for an adjournment to allow him time to get the license squared away as opposed to pleading guilty. To driving suspension.
30 days. September 11th at 9:30. Any questions today, sir? Any additional matters for the record, counsel?
Nothing from the people, Your Honor.
Nothing for the defense, thank you.
Okay, you can have a seat. We'll get you a copy of your notice to appear. On the record in the matter of the people of the state of Michigan versus Bradley Merchant Savage, file number 22-01923, counsel appearance.
Jeff Radowitz on behalf of the people, Your Honor.
Assistant Public Defender John Lee on behalf of Bradley Merchant Savage.
Okay, today is the date that was set for pre-trial on 1 count of domestic violence. How are we proceeding?
Yes, Your Honor, at this time, the people have made an offer for the defendant to plead to count 1 domestic violence with an agreement to 76948 if eligible. And with that, I would leave it to the defense.
Your Honor, Mr. Merchant Savage, having just learned of the offer, would like to take some time to consider it. We request setting the matter for final pre-trial and trial at this time.
Final trial October 2nd, 8 a.m. Trial October 16th.
Pre-trial October 2nd, in person at the court, 8 o'clock in the morning. Your jury trial will be October 16th, 8 o'clock in the morning, in person at the court. Okay, Mr. Merchant Savage?
Yes, sounds good, Your Honor. Thank you.
No problem. Do you have any questions today?
I'm doing a year-long program at the Odyssey House in Flint. Is there any way that I could do it through Zoom if they're not able to take me to Lansing?
Yes, your final pre-trial will be via Zoom.
Okay, thank you, ma'am. Oh, Your Honor.
Any additional questions, sir?
No, Your Honor.
Okay, you're all set. Thank you.
Yep, thank you.
Is Reese Martin here? Reese Martin present? Okay, there was a motion to adjourn. It's in the file. On the record in the matter of the people of the state of Michigan versus Davion Davis, file number 22-03207 and 22-03513, counsel appearance.
Jeff Radowitz on behalf of the people, Your Honor.
Assistant Public Defender Sarah Donnelly on behalf of the defendant Davion Davis. Well, I don't. He was set for a final pre-trial. I don't have him here in court, and I don't have a phone number for him. I tried to email. I haven't.
Okay, I'll let Chair Bench warrant. Set the final pre-trial at 10:30. Why? No, we only do final pre-trial at 8 o'clock in the morning. On the record in the matter of the people of the state of Michigan versus Noel Jackson, file number 23-00617, council appearance.
Jeff Roberts on behalf of the people, Your Honor.
Assistant Public Defender Sarah Donnelly on behalf of defendant Noel Jackson, who is appearing separately by video.
Say was the date that we reset this matter because the defendant was in the hospital at the last court date. I have one count here, operating while intoxicated. Second, how are we proceeding?
Yes, Your Honor, at this time, I believe last time this matter was set, an offer was made for the defendant to plead to the charge with a Killebrew agreement that upfront jail not exceed 7 days. With that, I would leave it to the defense.
Well, Your Honor, I had a discussion with the prosecutor and he is not opposed to being screened for 55th District Court sobriety court, and that's what I would like to have as 30 days for him to be screened.
Okay, the offer was,
Yes, Your Honor, that was also discussions last time that was that were had between, I believe, Mr. Cultrider out of my office and Ms. Donnelly, was that 55th sobriety court was also an option.
okay, I'm just trying to make sure I have the accurate offer because prosecutors rotate too quickly in here. And that means the offer rotates. What was the offer again?
Your Honor, it's my understanding there wasn't an offer. It was plea as charged with a Killebrew,
Okay.
you know, a 7-day max.
And you recognize though that the OWI second does have a sentencing of 5 days to 1 year, but there's also fines and minimum 30 days that must be imposed, correct?
Actually, I believe, yes, there is a minimum on a second offense.
Or you recognize that, correct? Yes.
I believe it is. Yes, I do believe that there is a 30-day upfront. That's why I would rather have him.
Yeah, that's the reason why I'm bringing that up is actually our clerk's office had to reach out, or our administration had to reach out because the prosecutor's office has been offering Killebrews on OWI seconds. And they can't do it. They can't do that. Okay, there is a mandatory sentence. Okay, with that being stated, we'll set this out so that he can be screened 30 days. Actually, give me 45 because it takes him some time.
October 2nd at 9:30.
October 2nd at 9:30 will be the new pretrial date. Do you have any questions today, Mr. Jackson? Does he speak English or is he an interpreter?
Your Honor, Mr. Jackson has needed an interpreter in the past, but I even asked him today, and he does not want to interpret for percent.
Mr. Jackson,
Yes.
you understand what I said?
No.
Okay. Why don't you understand what I said?
The problem is English.
He needs an interpreter.
Yes, I believe he speaks Swahili.
Okay. So we'll set it for new pre-trial still October 2nd with interpreter. In the meantime, you can still move forward with your process to have them screened.
Thank you, Your Honor.
I just said it because there is a request form in here for there to be a Swahili interpreter. That was supposed to be here today. I don't know why they're not. Okay, we'll get you an interpreter. We'll see you at your next court date, sir.
Thank you, Anna.
Thank you. Anthony Price, present.
Yes.
On the record in the matter of the people of the state of Michigan versus Anthony Devon Price, file number is 22-02655. Appearance, please.
Jeff Roberts on behalf of the people, Your Honor.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant Anthony Price was screened separately by video.
Okay, today's the date that was set for pretrial on an aggravated assault. How are we proceeding?
Yes, Your Honor, at this time, the people would make no offer. The defendant would be plea as charged, and with that, I would leave it to the defense.
Your Honor, yes, so we'd be setting it for final pre-trial and jury trial.
Final pre-trial, October 16th at 8 AM. And trial, October 3rd.
Final pretrial, wait, jury trial is October what?
I mean, October 30th.
Oh, okay. Final pretrial is gonna be October 16th at 8 o'clock in the morning in person at the court, Mr. Price, okay? You're muted, so I can't hear you. You're still muted.
My bad. Can you hear me now?
Okay, you got that court date?
That's October 16th.
October 16th, 8 o'clock in the morning in person.
Can I
Jury
speak to my
trial
lawyer real
will
quick?
be October, I'm sorry?
Can I speak to my lawyer real quick?
Okay, well, give me a moment. Your jury trial is gonna be October 30th in person, okay?
Oh, October 30th. They said 16th.
Nope, I said a final pretrial is gonna be October 16th at 8 AM, and then you'll have a jury trial October 30th.
All right, I got it. In person. I can't do it
You
over the
know,
phone
I
like
have a
we're doing
concern.
now?
Let me change your jury trial. I can't afford to do a jury trial on October 30th because if it runs the second day, we're gonna be in trouble. We have that trice exam on the 31st.
November 6th.
Okay, your jury trial is gonna be November 6th, okay?
November 6th, all right.
Yeah, Kelly was here when we said
In
that.
person.
We're doing the
Why
31st.
we can't do it over the phone?
I'm sorry?
I said, it ain't no possible chance we can do it over the phone.
Do what over the phone?
My jury.
That
selection
sounds
or whatever you
crazy.
just said.
That sounds absolutely ludicrous to me. A jury trial over the phone. That sounds bananas. Any other questions?
Nah.
Okay, very good. We'll see you in person, sir. Thank you. Let's see.
Can I go?
Yep, you're free to go. That was Price, and then, did we see Scott?
Scott is here, Your Honor.
Okay. Is he supposed to be having a hearing today? Is that what's going on, or arraignment? And what happened with Worthy?
Mr. Worthy is here.
Yeah. Yeah.
On the record in the matter of the people of the state of Michigan versus Rashawn Lakeith Worthy, file number 23-02053. Appearance, please.
Jeff Reynolds on behalf of the people, Your Honor.
Assistant Public Defender John Lee on behalf of Rashawn Worthy, who is present in the courtroom and standing to my right.
Okay, today is the date and the time that was set for a pretrial on a domestic violence. How are we proceeding?
Yes, Your Honor, at this time, the people have made an offer for the defendant to plea as charged to count of domestic violence with either 76948 if eligible, or the people would have no objection to HYTA if eligible. That would be up to, and then with that, I would leave it to the defense.
Your Honor, we're not sure that he is eligible for HIDA. We're going to do some research on that. Having just learned of the offer, Mr. Worthy would like a moment to consider it. Perhaps we can set this for final pretrial and trial and get it resolved at the next date.
No. That will Carter. No, I don't have the file. Yeah. Final pre-trial and jury trial.
Final pre-trial, October 16th.
October 16th at 8 a.m. in person for final pretrial.
And jury trial.
November 6th at 8 a.m. in person for jury trial. Do you have any questions today, Mr. Williams?
No, man.
Any additional matters for the record, counsel?
Nothing from the people, Your Honor.
Nothing for the defense. Thank you, Your Honor.
Arraignment. Okay, on the record in the matter of the people of the state of Michigan versus Sheena Marie Scott, file number 23-01015, counsel appearance.
Jeff Braddock on behalf of the people, Your Honor.
Good morning, I'm Vince on behalf of the finishing discussion, approaching the council bench.
Sorry, forgot about that.
In the steps, today's the date set for an arraignment on a probation, a bond violation, which is the PA 53. Okay, you were placed on bond back April 17th. Judge Flores, at the time, there was a no contact order in place for the protection of the alleged victim in this matter, that being Ms. Jamie Scruggs. You were not to be within 2,000 feet of where we live, works, or goes to school. You were not to have contact directly or indirectly, nor would you cause anybody else to have contact or third-party contact. I have a police report here that alleges that you violated the terms of your bond conditions by making contact with the alleged victim in this matter. Allegedly violating the 6-foot rule. I'm not sure what the 6-foot rule is. That's what it says in here. We weren't supposed to be within 2,000 feet according to my file, but the police report says there was some 6-foot rule. But if you were within 6 feet, then that would definitely be within or a violation of the 2,000 feet rule, because it's definitely closer than 2,000 feet. Nonetheless, also alleging a violation of not to engage in any assaultive or threatening behavior toward the alleged victim. Nonetheless, you have the right to have a contested hearing. At the time of the hearing, you have the right to be represented by counsel. You do have representation in the underlying matter, so they would be able to represent you if you proceeded to hearing in this matter. Let's see here. If you're found to be in violation of your bond condition, that's a contempt of court order. So the maximum penalty is 93 days in jail and or up to $7,500 in fines, or your bond can be revoked pending this matter. Do you understand that? Yes.
Yes, ma'am.
And then you would need to sit in jail until the time this matter is resolved. I am, however, reading the end of the report here about some video evidence or surveillance. The report does opine at the time of this report. The video was recorded, but could not find portions of the video that supported evidence in P3. Okay, so may or may not be video evidence. I don't know. I'll leave that to the prosecutor's office to determine whether or not there's video evidence to support that and turn that over to the defense counsel as needed for the purposes of her arraignment as to the bond violation, though, is she pleading not guilty?
Yes, sir.
Okay, looks like you have a jury trial set for August 14th.
That is correct.
Okay, we'll set the bond violation hearing for the same time. You have any questions today?
Nothing else. Thank you. Any questions?
Okay, your bond's gonna continue as is. I'm gonna reiterate and remind you of the no contact order and to not to be within 2,000 feet of the alleged victim. No contact directly or indirectly. You don't have anybody else contact him directly or indirectly on your behalf, okay?
Yeah, there's some confusion, Your Honor, concerning the 2,000 feet versus 6 feet because they are neighbors. And I think my client has indicated that the court did change it to a 6-foot rule
Yeah.
instead of 2,000. I have a problem with you.
You all are next door neighbors.
Yes.
Oh, that would explain the 6-foot rule. I do see where you're on GPS tether. You know, I had it removed. Had the GPS tether removed and that you were not to be within 6 feet.
And to help comply with that, Your Honor, my client, and this will be a date of the trial, but my client did put a fence.
Sounds good. So you're not to be within 6 feet of the defendant. Then you should have no communication or contact with him or have anyone else do any communication or contact on your behalf, okay? Okay, any questions?
Nothing else, Your Honor.
People, Your Honor.
You're all set, man.
We'll see you next week once we're on.
Thank you.
Thanks.
Okay, and then my understanding is that the jury is present. We need to get prepared to get them in here and then everything at 1:30. Let's see. We have some hearings. We have one arraignment. I'm going to do the arraignments for the probation violation, so we don't need to reset that. Probation violation hearings can be reset. And then there is a dog at large. MDOP. Who's representing McCollum?
I am representing Ms. McCollum.
Okay, Mr. McCollum.
Mr. McCollum.
Is there an offer on that, or is that the standard he needs to get a fence or something?
It would be with, well, counts 2 and 3 would be dismissed with compliance, Your Honor, and then be a plea to count 1 with restitution. Dog MDOP would be the offer on that one.
Okay, so I will expect that each one of the two of them could probably speak to him when he gets here at 1:30. And then we'll get him a new court date.